Now, the Pregnant Workers Fairness Act is another huge law that went into effect, started being enforced just over a year ago. I think the anniversary was last week. The Pregnant Workers Fairness Act is another law that protects lactating workers. It includes protections against discrimination, non-accommodation in the workplace for anyone who's pregnant, has a pregnancy-related condition like lactation. And it applies to workplaces with 15 or more employees. Um, those of you who have at least 15 employees are required to provide reasonable accommodation to employees who need them. And that could be things like light duty assignments, leave, even if someone doesn't have FMLA eligibility, or breaks to pump milk. The law also prohibits employers from retaliating against workers who request or receive reasonable accommodations related to their pregnancy or related condition. And again, this is a federal law that applies in addition to state and local laws. And the majority of states have similar laws already on the books. So hopefully this isn't totally new for all of you, but certainly a good thing to remember that these legal obligations stack. So again, look to the strongest protection.
And one thing I want to add about applies to 15 employees or more is a lot of times I get the question, is it 15 employees at a site or across the company? And it is across the company. So if you have a site with 14 employees and one with one that happens to have a pregnant mom, you need to make sure to support all your sites.
So the accommodation process is relatively similar to the process that we see for disability accommodations. It needs to be an interactive process. So this would come up likely when a lactating worker comes to you or comes to HR saying, I have this health need, I have to have some sort of change so that I can protect myself on the job. Then it is your designee's responsibility to assess that request, see if you can provide it. If it's not reasonable, if it would cause an undue hardship on your business in light of all of the resources available to you, then you need to engage in an interactive process to figure out if other options are available. And I have this TGIP here, timely. It should be a timely process. You don't want to keep workers waiting for a significant period of time, especially when it comes to pregnancy. Folks' health might be on the line very, very quickly. They often cannot wait for a long, drawn out process. The conversation needs to be in good faith, where everybody's coming to the table with the intent of working this out and finding a solution that keeps the employee working. And then interactive, a true interactive process. This is not just send one quick email saying, no, we can't do it, and you're done. Some back and forth listening and collaboration is expected in this process to determine if there is any option available to keep this worker on the job while also protecting their health. I mentioned that the process is very similar to the ADA, but there are some pretty important differences when it comes to the Pregnant Workers Fairness Act. And I think the biggest one here is documentation. The EEOC has now put out its final regulations on how they're going to enforce the Pregnant Workers Fairness Act. I encourage everyone to take a look at them. They are long, but it is incredibly, incredibly helpful. And one of the important aspects that they address is the documentation requirement. So under the Pregnant Workers Fairness Act, documentation cannot be requested for lactation breaks or space or other needs that are obvious. So for example, getting a new uniform or bathroom breaks. Documentation can only be requested for less obvious limitations or accommodations. And in addition, what you request of the employee has to be relatively narrow as well. So employers can only request documentation that describes or confirms the condition or limitation involved. Again, this doesn't have to be a huge complication of pregnancy. It could be any limitation at all. Maybe it's I need to stay off my feet. I can't be on my feet for more than an hour at a time, or I have to wear a mask on the job because I'm at higher risk. It does not have to be anything severe, but so the documentation should describe that there is a condition or limitation. Formal diagnosis isn't needed. It can confirm that the limitation is related to or arises out of pregnancy or a pregnancy-related medical condition. So again, that very important link between pregnancy and this accommodation request. And then finally, employers can request documentation that would describe or confirm that that change or adjustment at work is needed to address the limitation. So it's really very simple. It could be, Jane needs to sit down for at least 15 minutes, an hour, because of this pregnancy related health condition. We expect this is going to last for about 3 months. You don't need to know the entire medical history or the details of everything going on. Under the PUMP Act's the Pregnant Workers Fairness Act's very limited documentation standard.